Welcome back to the Deep Dive. Today, we're jumping into the Fourth Amendment of the U.S. Constitution.
That's right, the one about searches and seizures.
Exactly. You want the quick scoop on what it protects you from, unreasonable searches specifically, and that's our mission today.
Yep, we'll be looking at the text, its history, and crucially, how it actually plays out now for everyone.
For everyone inside the U.S., yeah. We want to pull out those core protections, but also, the tricky parts. Who's covered? Where? What are the limits?
And it's got deep roots, this amendment. It wasn't just invented out of thin air.
Right. Ratified back in 1791.
Yeah, December 15th. It was a direct pushback against those British general warrants, the writs of assistance, basically blank checks for searches.
The colonists hated those.
Understandably. And there were big legal fights in Britain even before that, like Wilkes v. Wood and Entick v. Carrington in the 1760s, challenging that kind of power.
So the core protection. No unreasonable searches and seizures. That's the key word. Unreasonable.
It really is. And the gold standard for making a search reasonable is getting a warrant first.
Based on probable cause.
Yeah.
So not just a hunch.
Definitely not. Probable cause means having, solid reasons to believe a crime happened or evidence is there. But it's not just about physical places anymore, is it?
No, not since Katz v. United States. That case brought in the whole idea of a reasonable expectation of privacy.
Exactly. Wherever you have that expectation, the Fourth Amendment potentially applies, which brings us to technology.
Always a complication.
Right.
Like with thermal imaging in Kylo.
Right, or cell phone location data in Carpenter. The courts are constantly trying to figure out how these old principles fit or don't fit with new ways of surveilling people.
It keeps things, evolving. Now, the amendment uses the phrase, the people, not citizens. That seems deliberate.
Very deliberate. And generally, courts have interpreted the people to include non-U.S. citizens who are physically present in the country.
So if you're here, even undocumented perhaps, you likely have Fourth Amendment rights against unreasonable searches by federal or state officers.
Generally, yes. The Verdugo-Urquidez case mentioned needing substantial voluntary connections, but being physically present is usually key. Unlawful presence itself is typically a civil matter, not automatic grounds for a criminal search.
Okay, but then there's the border. That seems like a major exception.
Oh, absolutely. The border search exception is huge. At the actual border, or its functional equivalent like an international airport checkpoint.
They can do routine searches without a warrant, or even suspicion.
That's a standard view, yes. It's grounded in the idea of national sovereignty, the government's right to control who and what comes in. This power extends quite a way inland, too, in that 100-mile zone CBP operates in.
But there are limits even there.
For sure. Routine searches, like looking through luggage or a quick pat-down, are usually fine without suspicion. But more intrusive searches, say a strip search, require at least reasonable suspicion. They're considered non-routine.
What about phones and laptops at the border? That feels different. Our whole lives are on there.
That is the hot-button issue right now. Inside the U.S., the Riley decision means police generally need a warrant to search your phone when they arrest you.
But not at the border.
It's murky. Federal courts are actually split. Some say basic searches might not need suspicion. Others argue that digging deep, like a forensic search, needs at least reasonable suspicion.
So, practically speaking, if you're traveling internationally,
the advice is often travel with less data, use encryption, maybe turn devices off before you get to the border checkpoint. Be aware it could be searched.
Okay, besides the border, there are other times police don't need a warrant,
yeah.
Right? These exceptions seem common.
Very common. The warrant clause is almost swallowed by the exceptions sometimes. Consent is a big one.
If you voluntarily agree to a search.
Right. And they don't have to tell you that you can refuse. Then there's plain view.
If they see something illegal out in the open, and they're legally allowed to be where they are.
Exactly. Incriminating nature has to be immediately apparent, though. Can't pick something up and examine it closely without probable cause.
What about emergencies? Exigent circumstances?
Yeah, things like chasing a fleeing suspect, preventing imminent danger, stopping evidence from being destroyed. But there are limits, can't usually barge into a home for a minor offense, and police can't create the emergency themselves just to get around the warrant rule.
And searches during an arrest. Sila.
Search incident to lawful arrest allows officers to search the person and the immediate area, the wingspan, for weapons or evidence. But Riley carved out cell phone data from that. And for cars, the Gantt case limited searches significantly unless they expect to find evidence of the crime of arrest in the car.
Cars seem to have their own rules anyway, the automobile exception.
Right, because they're mobile and seen as having less privacy than a home. If police have probable cause to believe a car contains contraband or evidence, they can generally search the whole thing, including containers inside.
Even passenger stuff.
Often, yes. But they can't search a car parked right next to your house in the curtilage without a warrant, usually.
And finally, those brief stops on the street. Terry stops.
Terry stops. Police need reasonable suspicion, less than probable cause, that someone is involved in criminal activity to stop them briefly. And if they also have reasonable suspicion the person is armed and dangerous, they can do a limited pat-down, a frisk, just for weapons.
Wow, okay. So it's this constant tension, isn't it? Individual privacy versus the government's need to enforce laws and ensure safety.
That's the fundamental balance the Fourth Amendment tries to strike. And it's a moving target.
Especially with technology just constantly pushing the boundaries.
Constantly.
So here's something for you to think about. As technology like AI, facial recognition, and mass data collection becomes even more powerful, how will that shift this balance the Fourth Amendment represents? What could that mean for your personal sphere of privacy down the road?
A crucial question for our times.
That's our deep dive for today. Thanks for tuning in.
Thanks for diving deep with Deepcast AI today. If you enjoyed this, give us a like and definitely subscribe and ring that notification bell so you're first in line for our next exploration.